Next case is People versus Jackson. This is a 15-minute mini oral argument on the application. That means, Mr. Monahan, you may attempt to reserve time, and if you are ready, you may proceed.
Thank you. Matt Monahan from the State Appellate Defender Office. On behalf of Mr. Jackson, may it please the court. As the state concedes, Mr. Jackson's current sentence is based in part on acquitted conduct. Although Mr. Jackson's jury acquitted him of possessing the firearm, the sentencing court scored OV1 as if Mr. Jackson used a firearm. As this court clearly and recently held in People v. Beck, reliance on acquitted conduct at sentencing violates due process. And here, that unconstitutional fact-finding invalidates Mr. Jackson's sentence and requires remand for resentencing. I welcome the court's questions. Beck ushered in a sea change in this court's sentencing jurisprudence. And as the opinion below indicates, the trial courts and the courts of appeals are still learning how to apply it. So here, this court should affirm and make clear that the reliance on acquitted conduct at sentencing is inconsistent with the presumption of innocence, it's fundamentally unfair, and it disregards the jury's role as the ultimate fact finder. A resentencing is necessary to remedy the violation here because Mr. Jackson was sentenced as if that acquitted conduct occurred. And those facts are in the record that currently support this sentence. He's entitled to a resentencing where the trial court fashions a proportionate sentence that's consistent with the circumstances of the offense as found by the jury and consistent with fundamental fairness and the presumption of innocence.
Counsel, there can't be many cases left where defendants were sentenced under the judicial guidelines. Is that fair to say? Do you think I must be right about that?
I think yes. I think it's fair to say yes, given the time that's passed, yes.
And what's your response to opposing counsel's view that the appropriate remand would be a Crosby-type remand, some remand shorter than a full remand for resentencing? In the reply brief, we addressed the Crosby remand, and the problem with the Crosby remand is it takes the facts as they existed at the time of sentencing, and it asks something of a hypothetical question. Freed from the unconstitutional constraint on discretion, would you give the same sentence? But the problem with that process here is it doesn't remove the unconstitutional considerations that currently support the sentence, because the record as we have contains the constitutional violation. The other potential remand here, and it may be in line with what the state is suggesting, is an articulation for reasons. But there too, that remand is a situation where the record isn't clear. Do we have a lawful sentence? Do we have an unlawful sentence? Because it's missing particularized reasons to support, say, consecutive. Here, the particularized reasons violate the Constitution. And so there isn't that question. What is the lawfulness of the sentence? We know that acquitted conduct factored into Mr. Jackson's sentence. That violates due process, and the only remedy is a resentencing. Unless the court has further questions, I'd like to reserve my time for rebuttal and ask this court remand for resentencing. I don't see any questions at this time.
Thank you.
Thank you.
Good morning. May it please the court, Brittany Teratuta, Wayne County Prosecutor's Office, on behalf of the people of the state of Michigan. I'm going to waive any of my free fire time and invite the court for questions. But I do just want to make clear the people are asking this court to deny defendant's application because defendant is not entitled to resentencing because we are under the judicial guidelines. So I want to take you guys back to pre-1999. These guidelines were not the force of law. And so while we did concede Beck, and that defendant gets the benefit of Beck because he was on direct appeal, we aren't saying that Beck should apply to this case because these are the judicial guidelines. And like I said, they don't have the force of law. These were just an aid to the trial court to sentence a defendant. And
but isn't the problem like the category of the error, not the way in which the guidelines operated? And if it's a constitutional error, how do we say this case isn't governed by our opinions in Mitchell and Raby and cases like that?
Well, we aren't saying this is a constitutional error because we're saying that Beck shouldn't apply because they're the judicial guidelines. And because the judicial guidelines had no force of law, there are very few, if any, cases that are resentencing on the judicial guidelines over OV scores because the OVs, sorry.
No, I'm sorry. I think I might have misunderstood your concession then, because I thought your
think
briefing and your presentation were saying we concede there's a Beck error, which is
and
sort of conceding there's a constitutional error.
And I'm glad that when we did concede, you guys didn't just write an order and say, bye. I'm glad I got to come up here and present to you what really like our true argument is.
Yeah.
Yes, Beck could apply to defendant because he was on direct appeal. But because we're at the judicial guidelines stage pre-1999, these have no force of law. So how the judicial guidelines weren't supposed to be for the appellate courts to rescore and score OVs. They were just an aid, and they're not the legislative guidelines like we have today. I guess that's what I'm trying to say, is that it's just a different time. And back then, they gave the trial court a lot more discretion, and these ranges were wide ranges, and we have a range here that even if you did score OV1 at 0 or 50, the defendant's sentence is proportionate to the range. And so while we also stated that we should have no resentencing, we don't object to sending it back for a remand to see if the trial court would have sentenced defendant a different way, knowing that a firearm should not have been scored.
I think I get it.
I hope that's clear. It's gonna be, I thought this was gonna be an easy case, and then it was like, it became a big thing.
Does the fact that the home invasion conviction was eventually vacated by the Court of Appeals on direct appeal play into whether this conduct is actually based on acquitted conduct in violation of Beck?
I don't believe so. I don't believe so. I think the home invasion, because it was vacated, it shouldn't matter for the OVs here, or at least OV1.
The only thing left then is scoring on the basis of a firearm, right?
Or a dangerous weapon. And the Court of Appeals below had based their opinion on it could have been a dangerous weapon, and that's why they upheld the 15 points. And for me to come up here and tell you that it could have been a dangerous weapon, there was nothing on the record that I could have pointed to give you that.
Okay.
But to not question the jury, we don't know. And if the court doesn't have any other questions, I will happily sit down.
I don't see any. Thank you very much.
Thank you.
It's the best argument of the day.
The state's concession of the Beck error does work here because Mitchell, Raby, and Francisco all agree that one way to invalidate a sentence is to factor constitutionally impermissible considerations into that sentence. And that line of cases is what authorized, and in this case, requires a remand because the system for assessing proportionality and crafting a proportionate sentence, it broke down here. The proportionate system depends on the consideration of offense circumstance.
Counsel, how do you respond, and if you could just help me with this, and I appreciate, all the arguments, but how do you respond at the end of the day it did fall within the sentencing guidelines?
It does fall within the sentencing guidelines, but a proportionate sentence, or even a sentence in the guidelines, can still violate due process because it includes conduct that's safeguarded by the presumption of innocence.
Right.
And although
But it still
sentencing
falls within, at the end of the day, I hear all the arguments, but at the end of the day, it still falls within the guidelines.
Although it falls within the guidelines, and sentencing, it isn't a math problem, Your Honor. It's a determination of the snow factors. Here, there's a change in the relationship between Mr. Jackson's current sentence and the correct range. Mr. Jackson was sentenced in the middle of the incorrect range, but his current sentence would be at the top of the correct range. And given that change in relationship, we don't know what a proportionate sentence is here, and it's the trial court that gets the first chance at making that decision, and doing so without consideration of the acquitted conduct here. And that's the need for a remand. It's because, yes, it's a sentence that's in the correct guidelines, but those guidelines have changed, and the court has to determine proportionality with constitutionally permissible fact-finding. For that reason, this court should remand for a resentencing. Unless this court has any further questions.
Thank you, counsel. Thank you both. The case will be submitted.